Can the burden of proof shift during a trial? In recent discussions surrounding courtroom procedures, one question stands out. Can the burden of proof shift during a trial? This topic has gained attention as legal cases unfold, making it relevant for many viewers. Understanding this concept is essential for anyone interested in how trials operate. Typically, the burden of proof rests with the party making a claim. In criminal cases, this is usually the prosecution, while in civil cases, it is the plaintiff. They must gather enough evidence to meet specific legal standards. For instance, in criminal trials, the standard is often beyond a reasonable doubt. In civil trials, it is usually preponderance of the evidence. However, there are instances when the burden of proof can shift. This process is known as burden shifting. In some civil cases, once the plaintiff presents sufficient evidence to establish a prima facie case, the burden may shift to the defendant. The defendant then must provide evidence to counter the plaintiff's claims. In criminal cases, the burden of proof generally remains with the prosecution. Yet, there are exceptions. For certain defenses, like insanity, the defendant may need to present some evidence. This requirement can change the dynamics of the trial. It is important to note that burden shifting is not automatic. It depends on the specific laws and rules governing each case. Courts must ensure that shifting the burden does not infringe on constitutional rights. For example, the presumption of innocence in criminal trials is a fundamental principle that must be upheld. Understanding the rules around burden shifting can clarify how courts maintain fairness in trials. While the burden of proof usually lies with the party making the claim, it can shift under specific legal circumstances. Keeping informed about these rules helps us appreciate the complexities of the legal system and how justice is served.